In February 2018, a bankruptcy trustee listed a residential development's common area infrastructure for $2.3 million. The pool facility, the community center, 3.8 miles of private roads, the entrance gate, everything in the development that wasn't a residential lot, titled to a holding company, part of a bankruptcy estate, available to whoever read the liquidation schedule first. I read it on a Tuesday. I closed the following month. The HOA president signed the license agreement on April 3rd, 2018. He asked 3 clarifying questions, signed without negotiation, and understood exactly what he'd signed. Then he moved to Savannah in June 2021. He didn't tell anyone. 4 boards, 14 members over 5 years. Not one pulled the county deed to verify what they actually owned. They renovated my pool, resurfaced my roads, built an addition onto my community center, upgraded my entrance gate, $771,000 in homeowner assessments, spent on my property, without asking me. I live 400 feet away. Then one Tuesday morning in March, the architectural review chair stepped off her porch with a clipboard and told me my mailbox post was the wrong color. When I said I wasn't under her HOA, she called the police. The officer arrived, sat at my kitchen table, read the deed. Then he looked up and asked if I owned the whole neighborhood. I told him to read the asset schedule. Before we start, tell me where you're listening from today, and if you're enjoying the content, hit like and subscribe for more stories just like this. The dog's name was Archie, a 7-year-old Rhodesian Ridgeback who had walked Briarwood Court every morning at 7:15 for the entirety of his life, and who had strong opinions about which grass verges were worth investigating and which were not. I had bought Archie the same year I had bought the trust. Both had been good decisions. The morning was a Tuesday in mid-March, cool enough for a jacket, the kind of Piedmont, Carolina morning that can't decide whether it's still winter or already spring. The Bradford pears on the east side of Briarwood Court were blooming, the specific brief white that lasts 10 days and then becomes a sidewalk problem. And Archie was conducting his usual investigation of the verge in front of 14 Briarwood Court when I heard her step off the porch. I had seen Patrice Lemon at 2 community events in the 6 years I had lived on this street. She had been HOA architectural review chair for 4 of those years, a position that, in Briarwood Commons, carried the specific authority to issue violation notices and the specific temperament of someone who took that authority seriously. I knew who she was. She did not, in any meaningful sense, know who I was. She had a clipboard with 3 sheets attached. Mr. Osei. She said my name with the careful pronunciation of someone who had looked it up beforehand. Osei, which I noted because most people don't bother. I've been meaning to catch you. I have some compliance items for your property. Archie looked at her clipboard with the mild interest of a dog who has learned that clipboards don't throw balls. Go ahead, I said. She went through them in order, which I respected. Lawn edging along the front property line. The edging had grown irregular, she said, and the CC&Rs required a maintained edge of no less than 3 inches from the sidewalk boundary. My mailbox post, the current color, a dark charcoal gray I had painted it myself 4 years ago, was not on the approved exterior color palette, which allowed 8 shades of brown, 2 shades of black, and hunter green. My front door, which I had painted a deep navy blue when I moved in, needed to be brought into compliance within 30 days. The approved door colors for Briarwood Court properties ran to 3 shades of red, 4 neutral tones, and a dark green that was emphatically not navy. She delivered all 3 items with the smooth efficiency of someone who had done this many times, and had developed a professional register for the homeowner who was about to object. I let her finish completely. I had learned, over 11 years of real estate investment work, that interrupting people in the middle of their prepared remarks is inefficient. You learn more by letting them reach the end. When she finished, I said, "I'm not under your HOA." The clipboard came down slightly. Every property on Briarwood Court is subject to the Briarwood Commons CC&Rs, Mr. Osei. It's recorded in the county. Pull my deed from the county recorder's office. The address is Lot 1, Briarwood Commons, the parcel at the development entrance. It's public record. You can access it online or at the counter. Either way, it costs nothing and takes about 4 minutes. Sir, I have the CC&R map and your address falls within the CC&R map shows which lots are subject to the covenants. My lot is on the map. Look at what the map says about my lot specifically. I gave Archie a slight lead correction. He had found something interesting in the verge, and I wanted to keep moving. Have a good morning, Ms. Lemon. I walked home. Patrice called the municipal non-emergency line at 9:52 a.m. I know the time because Officer Daniels, when he arrived, showed me the dispatch record, a courtesy he extended with the specific awkwardness of a law enforcement officer who has been sent on a call that is clarifying itself rapidly as something other than what was reported. The complaint had described a resident at Lot 1, Briarwood Court, who was refusing to engage with HOA authority and claiming exemption from the community's CC&Rs. Patrice had requested an officer visit the property to confirm HOA jurisdiction and document the resident's non-compliance posture for the HOA's enforcement file. Officer Daniels arrived at 11:40 in a marked unit. He was courteous at the door, mid-30s, professional, the practiced neutral expression of someone who has been dispatched to a lot of neighbor disputes and has developed a methodology for them. I invited him in, offered coffee, which he declined. We sat at the kitchen table. Mr. Osei, I received a call regarding a dispute about HOA jurisdiction at this address. Can you help me understand the situation? Of course. I went to my home office, the second drawer of the filing cabinet beside the desk, where I keep the property documents I access most often, and came back with the folder. I set it on the table and opened it to the first document. The title certificate for Lot 1, Briarwood Commons, my personal residence, the corner property at the development entrance. Titled in my name individually, not through the trust, as I had structured it on Grace's advice when I closed. The title certificate included the original CC and R exclusion notation from the developer's 1998 declaration, a two-line carve-out in the recorded instrument, buried in Section 14 among the definitions, that excluded Lot 1 from the HOA's covenant jurisdiction. I let him read that. Then I set the second document on top of it, the trust instrument summary and the 2018 acquisition deed, the document recording the transfer of the Hargrove Development Group holding entity's assets to the Raymond Osei Land Investment Trust. The asset schedule was attached, the common area parcels, the amenity facility parcels, the road infrastructure, the entrance parcels, all of Briarwood Commons that wasn't an individually owned residential lot. Officer Daniels read for approximately 2.5 minutes. His expression moved through several phases: focused reading, a slight forward lean, a second pass at the asset schedule, and then the stillness of someone reassembling their understanding of the situation they have walked into. He looked up. Sir. He set the document down with the careful placement of someone handling something they want to treat with respect. You own the whole neighborhood. The infrastructure, I said. The common areas, the amenity facilities, the roads, the entrance. The residential lots belong to the individual homeowners. But everything in between, everything the HOA has been treating as common property for the past 6 years, is titled to my trust. He looked at the document again, then at me. And your lot was carved out of the HOA's jurisdiction in 1998 by the original developer. I kept that carve-out when I purchased the trust assets. My property has never been subject to the Briarwood Commons CC and Rs. A silence. Officer Daniels picked up his radio, considered it, set it back on his belt. He looked at the folder on my kitchen table with the expression of a man recalibrating the call he was going to have to make to dispatch. Mr. Osei, is there anything you'd like me to convey to the HOA regarding this situation? Tell them, I said, to read their license agreement. He wrote that down. I called Grace Lim at 2:30 that afternoon. Grace had been my property attorney since 2016, before the trust, before Briarwood, back when I was acquiring individual rental properties in the Charlotte Metro, and needed someone who read title documents the way other people read novels. She had structured the 2018 trust acquisition, drafted the license agreement with the HOA, and conducted the 2022 audit that had first surfaced the unauthorized capital projects. She answered on the second ring. The architectural review chair called the police on me this morning, I said. A beat. Over what? My mailbox post color. A longer pause. The pause of an attorney processing the specific absurdity of a situation and deciding how to categorize it. Raymond. She had 3 violation notices: lawn edging, mailbox color, front door paint. And you told her, I told her I wasn't under the HOA and suggested she pull my deed. She called the non-emergency line instead. An officer came to the house. I showed him the title documents. What did he say? He asked if I owned the whole neighborhood. Grace was quiet for a moment. I could hear her pulling up a document, the specific keystroke pattern I had come to recognize over 9 years of working together. This is the moment, she said. It wasn't a question. I've been patient for 3 years, I said. 4 unauthorized capital projects on my titled property. $771,000 in homeowner assessments spent on land the board doesn't own, without my consent, and for the last 18 months without any response to your 2023 letter beyond under review. I looked out my front window at Briarwood Court, the road curving into the development, the entrance gate visible at the corner, the landscaped common area that bordered my lot. Patrice Limon called a police officer to come to my home to tell me I had to repaint my mailbox post. She handed you standing in a timeline, Grace said. File everything, I said. All 4 projects. The license agreement breach, the assessment collections, whatever the AG's office will take on consumer protection, the whole picture. I'll have the formal notice ready by Thursday, she said. Make it 14 pages, I said. I want them to understand what they've been standing on. I took Archie for his evening walk at 5:45. The same route, the same direction, past the same Bradford pears. I walked past Patrice Lemon's house. Her car was in the driveway. The lights were on in the front room. I had no way of knowing whether Officer Daniels had called her back with what he'd found on my kitchen table, or whether she was still operating under the assumption that a follow-up violation notice and a firmer tone would resolve the mailbox post situation. I walked the full circuit of Briarwood Court, the loop that takes 22 minutes at Archie's preferred pace, through the development's interior roads, past the pool facility, past the community center, past the entrance gate at the corner. My pool facility, my community center, my gate. Titled to my trust since February 2018. Maintained by an HOA that had been operating for 6 years, as though the 2018 ownership transfer had never happened, and the license agreement Walt Grover had signed was a document that had ceased to exist when Walt moved to Savannah. I had been patient, because patience is, in property matters, almost always the correct strategy. You wait until the record is complete. You wait until the unauthorized activity has documented itself thoroughly enough that the legal action, when it comes, is not contested on the facts. You wait until the moment when the cost of continuing to ignore the problem exceeds the cost of resolving it. 3 years, 4 projects, $771,000. A police officer at my kitchen table asking if I own the whole neighborhood. The moment had arrived. I walked Archie home, fed him his dinner, sat at the kitchen table with the folder still open, and looked at the asset schedule. The list of parcels, the road mileage, the facility addresses, that represented everything the Briarwood Commons HOA had been treating as its own for 6 years without checking who held the title. The mailbox post was still charcoal gray outside my front door. It was going to stay that way. Grace called me Thursday morning with the full chain of title assembled. She had spent 2 days pulling records. The original 1997 Hargrove Development Group filings, the subdivision plat, the CC&R declaration, the holding entity's corporate documents, the 2017 bankruptcy filing, the trustee's asset liquidation schedule, and the 2018 acquisition deed. 26 years of ownership history on a 340-lot residential development, compressed into a chronology that explained how a land investment trust in my name had come to hold the infrastructure of a neighborhood where 340 families were living their lives without knowing who owned the ground beneath their community center. Start at the beginning, I said. Hargrove Development Group broke ground in 1997, Grace said. Standard residential development for the period. They platted the lots, built the roads and amenities, sold the homes with CC and Rs attached. The covenants ran with the individual lots and created the HOA as the enforcement mechanism, standard structure. But they split the ownership, deliberately. Hargrove created a separate holding entity, Briarwood Commons Infrastructure LLC, and titled everything that wasn't a residential lot into that entity. The common areas, the amenity parcels, the road network, the entrance infrastructure. The LLC held the bones of the development, while the HOA governed the residential lots. This was not an unusual structure in late 1990s residential development. Developers retained the infrastructure assets as a revenue stream. They could charge the HOA for access to the common areas and amenity facilities, or sell those assets later to a third party. The HOA got governance authority. The developer kept the property. Hargrove ran the development for 20 years, Grace continued. The holding entity collected modest license fees from the HOA. Minimal, grandfathered rates, not commercially significant. Then Hargrove overextended on 3 other projects in 2016 and 2017, and the whole corporate structure went into Chapter 7 in November 2017. The bankruptcy. The trustee took over the holding entity's assets as part of the estate. Briarwood Commons Infrastructure LLC's parcel inventory went onto the liquidation schedule in early 2018. It was not a high-profile asset, a collection of common area parcels, road right-of-ways, and 2 amenity buildings in a mid-size residential development in Cabarrus County. The trustee listed it at $2.3 million. I had found the listing through a bankruptcy asset monitoring service I had subscribed to since 2014. A professional tool that flagged real property liquidations in the counties where I was actively investing. The Briarwood Commons listing had come through in February 2018. I had driven the development that weekend, walked the common areas, reviewed the plat, and called Grace on Monday. "Tell me about the license agreement," I said. "That was my condition for closing," Grace said. "You were acquiring property that a functioning HOA was using and maintaining. Without a formal agreement, you'd have had an ambiguous relationship with the HOA from day one. Are they trespassers? Licensees? What are their rights? What are yours?" The license agreement resolved all of that. She had drafted it over 2 weeks in March 2018. It was 11 pages, recorded with the county on April 3, 2018, the same day the acquisition deed was recorded. Any title search on any Briarwood Commons parcel conducted after April 3, 2018, would surface the license agreement as a recorded instrument affecting the development. Walt Grover had been HOA president for 4 years when he signed it. He had read it, asked 3 clarifying questions. Grace remembered the call, and signed without negotiation. The agreement was fair to the HOA. They retained full use rights for the common areas and amenity facilities. The license fee was nominal, and their covenant enforcement authority over the residential lots was unaffected. The one provision that mattered, the one that would become the center of everything, was Section 6. No capital improvement, structural modification, or permanent installation shall be made to any trust-titled parcel without the prior written consent of the Raymond Osei Land Investment Trust, executed through a signed improvement agreement as described in Exhibit B. Capital improvement is defined as any expenditure exceeding $5,000 directed toward the alteration, enhancement, or expansion of any structure, parcel, or infrastructure asset titled to the trust. Walt understood Section 6. He had asked about it specifically during the call with Grace. His question: what counts as a capital improvement versus routine maintenance? Grace's answer: anything over $5,000 that changes the condition of the parcel. Repainting a fence is maintenance. Building an addition is a capital improvement. Walt had said, understood. He had not put that understanding into the board's institutional record. He had not added it to the HOA's officer handbook, the board orientation materials, or the annual governance checklist. He had signed the license agreement, filed it with the county, and carried the knowledge of what it meant in his own head for 3 years, until he accepted a job offer in Savannah and left Briarwood Commons in June 2021. Did he tell anyone before he left? I asked. Not in any record I can find, Grace said. His resignation letter to the board is in the HOA's files. It thanks the community, recommends his successor, and says nothing about the license agreement. The asset list Grace assembled was a document I had seen before, the original acquisition schedule from the 2018 closing. But reading it fresh, in the context of what the HOA had been doing with these assets for 6 years, gave each line item a different weight. The pool facility and its 1.4-acre parcel. A community pool with a deck, a pump house, and a surrounding green area, purchased by Hargrove in 1999 as an amenity to drive residential lot sales, retained in the holding entity, acquired by my trust in 2018. the pool facility where Briarwood Commons families had been swimming every summer for 2 decades. The pool facility the HOA had renovated in 2021 for $340,000 without asking me. The community center and its 2.1-acre parcel, a single-story building with a meeting room, a kitchen, and a small fitness area. The building where the HOA held its monthly board meetings, where the neighborhood's book club met on Thursday evenings, where the holiday party was held in December. My building. The building onto which the HOA had added 1,400 square feet in 2023 without a signed improvement agreement. The road network, 3.8 miles of private internal roads, titled to the trust since the original development plat. Every vehicle that drove into Briarwood Commons, every school bus, every delivery truck, every resident commuting to work, was traveling on roads that belonged to my trust. The roads the HOA had resurfaced in 2022 for $180,000, using homeowner assessment funds on infrastructure they did not own. The entrance infrastructure, the gate, the stone monument signage, the lighting columns on both sides of the entry drive, the landscaped buffer at the development street frontage, the gate, the HOA had upgraded in January 2024 for $95,000. Approved 3 months after Grace's 2023 notice, had placed the board on written record of the consent requirement. All of it. 340 households using amenities, driving roads, entering through a gate that was, in a precise legal sense, mine. And the HOA, the entity with the clipboard and the violation notices, and the Architectural Review Authority, held none of it. The Briarwood Commons HOA was a governing body without property. It had the authority to tell a homeowner their shutters were the wrong color. It had no authority over the land beneath the shutters. What does the HOA actually own? I asked Grace. Their bank account, she said. Their corporate documents. Their governing authority under the CC and Rs. A pause. That's it. The gap between Walt Grover's departure in June 2021 and the moment Officer Daniels sat at my kitchen table in March 2026 was 4 years and 9 months. In that span, 3 HOA presidents, 7 board composition changes as members rotated on and off, a complete turnover of the board's institutional knowledge, and not one person, not one of the 14 individuals who had served on the Briarwood Commons board during those 4 years and 9 months had pulled the license agreement from the county recorder's office. It was a public record. It had been on file since April 3, 2018. The county recorder's online portal made it searchable by parcel number or grantor name. A board member with a laptop and 10 minutes of curiosity could have found it any afternoon since the day it was recorded. Not one of them had looked. I had thought about this in the 3 years since the 2022 audit had first flagged the unauthorized projects. I had spent time trying to understand how a functioning HOA board, people who were, individually, homeowners with jobs and families and sufficient organizational competence to manage a community governance function, had spent 4 years making capital decisions on property they had never verified they owned. The answer, Grace had suggested when I raised it in 2023, was the answer to most institutional failures. They had inherited assumptions rather than examined records. The board members who joined after Walt left had received an orientation from the outgoing president or a board buddy. The orientation covered dues collection, the C&R enforcement process, the annual budget cycle, the vendor relationships. It covered the practical operations of a functioning HOA. It did not cover the license agreement because the person giving the orientation did not know about the license agreement. Each successive board had operated on the foundation laid by the previous one, without ever descending to the level of the actual documents, the recorded instruments, the chain of title, the legal structure that determined what the HOA actually owned and what it merely used. They had been building on ground they had never surveyed. 4 unauthorized capital projects, $771,000 in homeowner funds directed to improvements on parcels the HOA didn't own. 18 months of non-response after Grace's 2023 letter had specifically identified the problem and named the violation. The confidence of people who had never checked the foundation they were standing on. "Grace," I said, when she finished walking me through the full record, "I want to understand the license agreement termination provision." "Section 9, she said. 3 or more material breaches, defined as capital improvements without consent, constitute grounds for termination with 30 days written notice. We have four documented, with financial records and contractor invoices attached. She paused. Raymond, you can terminate their access to the common areas, the pool, the community center, the roads. With 30 days notice, you can close all of it. I looked out the window at Briarwood Court, the Bradford pears still blooming. A resident from the far end of the street walking a stroller past my front lot, using the road that belonged to my trust, heading toward the community center that sat on my parcel. I'm not going to close the pool, I said. I know, Grace said, but they don't know that yet. Include the termination notice in the formal filing, I said. 30 days. Let them read Section 9 for the first time along with everything else. A pause. That, Grace said, is going to be a very interesting board meeting. The subpoena went out on Thursday afternoon. Grace had the HOA's registered agent served by Friday morning. 6 years of board meeting minutes, all financial records, all contractor correspondence, all internal communications related to capital projects on common area parcels, and all communications referencing the Raymond Osei Land Investment Trust, or the license agreement recorded April 3, 2018. The records arrived in Grace's Raleigh office the following Wednesday, in 4 banker's boxes and a USB drive containing scanned financial documents. She spent 3 days reading them before she called me. I want to be precise about what this is, she said when I answered. Because my first instinct was to call it willful. But I've read 6 years of minutes, and I don't think it's willful. I think it's something that's actually harder to defend in some ways. What is it? It's an organization that stopped asking foundational questions. Every board inherited the previous board's assumptions, and the assumptions were comfortable, and comfortable assumptions don't get examined. She paused. Until they become $771,000 worth of unauthorized construction on someone else's property. She walked me through the record in sequence. The pool facility renovation appeared on the Briarwood Commons HOA board agenda for the first time in January 2021. The board at that time was 4 months into its post-Walt era. Craig Weston had been elected president in September 2020. Patrice had taken the architectural review chair in the same election cycle. And the rest of the board was a mix of long-tenured members and 2 people who had joined for the first time that year. The pool facility was aging. The pump system dated from the original 1999 construction. The deck surface had been patched twice in 5 years and was developing structural concerns in the northeast corner. The pool's surround landscaping had become overgrown, and the HOA had received member complaints about its condition at 3 consecutive annual meetings. Craig had presented the renovation proposal as straightforward community maintenance, the kind of capital investment that any well-managed HOA would make to preserve its amenity infrastructure. The budget? $340,000, funded through a special assessment of $1,000 per household, collected across 2 installments. The board approved it unanimously. No one asked who owned the pool facility parcel. The question was not asked because the question did not occur to anyone to ask. The pool facility was, in the board's institutional understanding, HOA common property, the same category it had occupied in every board member's mental model since the development opened in 1999. The original residents had moved in, found a pool, and understood it as a community amenity. That understanding had passed forward through every subsequent board orientation, every new member briefing, every conversation in which a departing board member handed off their knowledge to an incoming one. Walt Grover, the one person who had known the pool facility, sat on a parcel titled to my trust, had left 8 months before the renovation was approved. The contractor who pulled the site permit in March 2021 listed the parcel owner as Briarwood Commons HOA on the permit application. The county permit office had processed it without flagging the discrepancy. Permit offices work from what applicants tell them, not from independent title verification. The permit was issued. Construction began in April. The renovation was complete by August. $340,000 spent on my parcel. Not a dollar of it authorized by me. Not a word of it mentioned to me. I had been living 400 feet away on Lot 1 for the entire duration of the construction. The road resurfacing project followed in the fall of 2022. The internal roads of Briarwood Commons, 3.8 miles of private road network, titled to my trust, had last been resurfaced in 2014, a project completed by Hargrove before the bankruptcy. 8 years of traffic had worn the surface in predictable patterns. The high-use sections near the entrance and the community center showed the most deterioration, with edge cracking and surface raveling at the intersections. The HOA had collected competitive bids from 3 paving contractors. They had selected the middle bid. They had approved $180,000 from operating reserves at the October 2022 board meeting, a vote of 5-0. The board minutes from that meeting described the expenditure as approval of road maintenance project, resurfacing of HOA road infrastructure, 2.4 miles, Phase 1, HOA road infrastructure. The roads had never been HOA infrastructure. They had been Hargrove infrastructure, then bankruptcy estate assets, then mine since February 2018. The phrase HOA road infrastructure appeared in those minutes because the board believed it was accurate. They had believed it for the same reason they had believed the pool facility was HOA property, because no one had told them otherwise after Walt left, and because comfortable assumptions, once established, tend to persist until something disturbs them. The paving contractor completed Phase 1 in November 2022, 2.4 miles resurfaced, the entrance approach and the main interior loop. Phase 2, covering the remaining 1.4 miles of secondary roads, had been discussed at the December 2022 meeting and deferred to the following budget year. It was never approved. Grace's 2023 letter arrived before the Phase 2 discussion could be reopened. The community center expansion was the project that had triggered the 2022 audit. I had noticed the construction during my morning walk in April 2023. Concrete forms going in on the north side of the community center building. A contractor's trailer parked on the common area adjacent to the facility. I had called Grace that evening. She had pulled the permit the following morning. A 1,400 square foot addition, new meeting room space, and an expanded kitchen designed to accommodate the HOA's growing programming needs. The contract was with a local general contractor for $156,000. The permit, again, listed the parcel owner as Briarwood Commons HOA. Grace had sent the formal notice on July 14, 2023. It was a 6-page letter, measured, specific, and precise in the way that Grace's correspondence always was. It identified the license agreement by recording date and instrument number. It quoted Section 6 in full. It identified the pool renovation and the road resurfacing as prior violations of the improvement consent requirement. It identified the community center expansion as a current, ongoing violation. It requested an immediate halt to construction pending execution of a proper improvement agreement, and it requested a written response within 21 days. The HOA's attorney, a general practice real estate lawyer in Concord named Herschel Dowd, who had been on the HOA's retainer for 2 years, responded on August 4th, 3 days after Grace's deadline had passed. His letter was 1 paragraph. It acknowledged receipt of Grace's correspondence, stated that the matter was currently under legal review, and indicated that the HOA would respond more fully once that review was complete. He did not instruct the board to halt construction. The construction continued. I had watched it from my morning walks through August, September, and October 2023. The framing going up, the roof being closed in, the exterior cladding going on. The addition was completed in November 2023. The contractor's final inspection was approved by the county on November 19th. Grace had read the completion notice in the permit database and called me the same afternoon. "They finished it," she said. "I know, I watched them finish it." "Raymond, they completed a $156,000 construction project on your parcel without an improvement agreement, 4 months after I sent them a letter specifically identifying the consent requirement and asking them to stop. I know what they did. This is no longer just institutional negligence. This is proceeding after notice." "I know that too," I said. "Keep watching. I want the full picture before we move." The full picture arrived in January 2024, when the entrance gate upgrade was installed. The gate project had been approved at the November 2023 board meeting. The same month the community center expansion was completed, 4 months after Grace's letter had placed the board on written record of the improvement consent requirement. $95,000 for a new automated gate system at the Briarwood Commons entrance, upgraded hardware, a new keypad and fob system, improved lighting on both sides of the entry drive. The entrance infrastructure sat entirely on parcels titled to my trust. The gate parcel was one of the first assets listed on the 2018 acquisition schedule. The approval had been unanimous, 6-0. 3 board members who voted yes on the gate project had read Grace's July 2023 letter. Grace had identified 2 of them through the internal communications the subpoena produced. Emails exchanged in late July 2023, after the letter arrived, in which the board members discussed what the license agreement meant and whether the community center construction should be paused. Board member Lynette Farrow to board member Derek Anston, July 28, 2023. Did you read the letter from the trust attorney? It says we need written consent for capital projects on HOA, common areas. We might have a problem with the community center. Derek Anston to Lynette Farrow, July 29, 2023. I forwarded it to Craig and Herschel. Craig said legal is handling it. I'd assume we're fine, or they'd tell us to stop. Lynette Farrow to Derek Anston, July 29, 2023. I hope so. Seems like it could be a big deal if it's real. It was real. It was a big deal. And Craig Weston's legal is handling it had functioned as institutional permission to stop asking questions that needed answers. I had read those emails in Grace's office the week the subpoena records arrived. I had read them twice. Lynette Farrow had known there might be a problem in July 2023. She had deferred to Craig's assurance. She had voted yes on the gate project in November, 16 months later, without ever receiving the more full response Herschel Dowd's letter had promised. At the August 2023 board meeting, 4 weeks after Grace's letter, 3 weeks after Lynette and Derek's email exchange, Craig Weston had addressed the license agreement question from the floor. His statement, as recorded in the minutes. The board has received correspondence from an attorney representing a private land trust, making claims related to our common area management. Our attorney is reviewing the matter. We will proceed with all planned projects as normal pending that review. 2 board members had asked follow-up questions. Lynette had asked what claims related to common area management meant specifically. Craig had said their attorney was best positioned to explain the details once the review was complete. Derek had asked whether the community center project should be paused during the review. Craig: no, we proceed as planned. 3 months later, he had brought the gate project to a vote. Total unauthorized capital expenditure on titled trust property, $771,000. Broken down, $340,000 on a pool facility parcel that had been mined since 2018, $180,000 on roads that had been mined since 2018, $156,000 on a community center parcel that had been mined since 2018, $95,000 on an entrance infrastructure parcel that had been mined since 2018, 4 projects across 4 years. The first 3 built on institutional ignorance, a board that had never read the license agreement because no one had told them it existed. The 4th built on something else entirely. The specific inertia of an organization that had been told there was a problem, had assigned the problem to a process, and had allowed the process to become a reason to keep doing what they were already doing. Legal is reviewing it. 4 words. Used once in August 2023. Sufficient to carry the board through a community center completion and a gate installation without anyone circling back to ask whether the review had concluded and what it had found. Grace set the final accounting document on the table between us. $771,000, 6 years, 4 projects. It started as negligence, she said. It ended as something the court is going to read very differently. I looked at the document. Draft the formal notice, I said. All 4 projects, the license agreement breach, the termination warning, the full accounting. I paused. Send it certified mail to every board member individually. I want each of them to sign for it. 7 board members, Grace said. 7 certified letters, I said. They proceeded as planned. Now they can read as planned. Grace filed the notice on a Thursday. 7 certified mail envelopes, addressed individually to each board member at their Briarwood Commons home addresses, because they all lived in the development, because they were all homeowners in a community whose infrastructure belonged to their neighbor, and because I wanted each of them to walk to their mailbox on the same morning and sign for the same envelope, and understand that the document inside was addressed to them specifically, not to a collective body they could distribute responsibility across. The notice was 14 pages. Grace had spent 3 days on the language, not because the facts were complicated, but because the document needed to function simultaneously as a legal instrument, a factual record, and a communication that would be read by 7 people who were about to discover something that would reorganize their understanding of the community they had been governing. Page 1. Raymond Osei's ownership documentation, the 2018 acquisition deed, the asset schedule, the trust instrument summary, everything needed to establish, without room for the response of, "We didn't know this was real," that the ownership was documented, recorded, and had been publicly accessible since April 2018. Pages 2 through 4. The license agreement in full, with Section 6's improvement consent requirement highlighted, and the Exhibit B improvement agreement template attached. Walt Grover's signature on the final page. The county recording stamp and instrument number. Pages 5 through 10. The project-by-project accounting. Each unauthorized capital improvement presented in the same format. Project name, approval date, completion date, total expenditure, parcel title holder, absence of improvement agreement, and the specific provision of Section 6 that the project had violated. Support documents tabbed behind each section. The board minutes authorizing the project, the contractor invoice, the permit application listing the parcel owner, the county deed confirming the parcel's title. The pool renovation tab was the thickest, 22 pages of supporting documentation for a $340,000 project that had been built on my parcel, with the parcel owner listed incorrectly on every official document, from the permit application to the contractor's completion certificate. Pages 11 through 13, the demand. A complete financial accounting of all expenditures on trust-titled parcels since April 2018, not just the 4 identified capital projects, but every expenditure that had touched my property in any way. Maintenance contracts, landscaping agreements, utility arrangements, insurance coverage for structures on trust-titled parcels. Page 14. Section 9 of the license agreement, quoted in full, with a notice of material breach based on 4 documented violations of Section 6 and a 30-day termination warning. Grace had also filed the notice simultaneously with the county recorder as a formal notice of claim against every trust-titled parcel in the Briarwood Commons development, a recorded instrument that would appear on any title search conducted on those parcels going forward. Any homeowner attempting to refinance, any buyer conducting due diligence, any lender reviewing a mortgage application would find the notice of claim as a recorded document affecting the development's common infrastructure. The envelopes were delivered Friday morning. I watched from my front window as the postal carrier worked down Briarwood Court. 7 stops, 7 signatures, 7 board members receiving the same 14 pages in the same sequence. The emergency session was called for Friday evening. Grace had anticipated it. The 30-day termination clock started the moment the notice was delivered, and a board facing the potential closure of its pool, community center, and road access was not going to wait until the next scheduled meeting to respond. 7 board members, the HOA's attorney Herschel Dowd, and, in a detail Grace learned from Roger Falk afterward, a second attorney that Craig Weston had retained personally and brought to the meeting without telling the other board members in advance. Craig's personal attorney's presence at the meeting told Grace everything she needed to know about how Craig was reading the situation. Patrice had arrived at the meeting with her copy of the notice and a highlighter. She had marked 12 passages. She was, Grace was told, the first person to speak after Herschel Dowd called the meeting to order. "I need someone to explain to me who Raymond Osei actually is," she said. "Not who he is as a neighbor, who he is in terms of this development." Herschel Dowd had been the HOA's attorney for 2 years. He had written the August 2023 response letter to Grace, the 1-paragraph acknowledgement that had promised further response and delivered nothing. He had been carrying the license agreement question in a file folder marked "Under Review" since July 2023. He had not shared the full implications of Grace's letter with the board because Craig had told him the board was handling it, and he had deferred to that direction without pushing back. He opened his laptop at the meeting table and pulled the county recorder's online portal. He typed in the Briarwood Commons parcel numbers. He ran the search. The results came back in 11 seconds. Owner of record for the pool facility parcel, Raymond Osei Land Investment Trust. Owner of record for the community center parcel. Raymond Osei Land Investment Trust. Owner of record for the road right-of-way parcels. Raymond Osei Land Investment Trust. Owner of record for the entrance infrastructure parcel. Raymond Osei Land Investment Trust. He turned the laptop screen to face the table. The room absorbed it in the specific silence that follows the confirmation of something people had been half suspecting since they read page 1 of the notice that morning, but had been hoping, in some operational corner of their minds, would turn out to be an error. It was not an error. Patrice, why didn't anyone tell us this? The question went to the table generally. The table did not answer generally. It answered in the specific distribution of eye contact that happens when a group of people are each calculating how much of a collective failure belongs to them personally. Craig Weston was looking at the surface of the table. Lynette Farrow, the board member who had emailed Derek in July 2023 about the license agreement letter, was looking at Craig. Herschel Dowd closed the laptop with the careful motion of someone who has just realized that the file folder marked under review in his cabinet is going to become a central exhibit in a legal proceeding. We need to talk about the 2023 letter, he said. Craig Weston's personal attorney put his hand briefly on Craig's arm. Craig said nothing. The 30-day clock was the fact that reorganized everything. The board members understood, from reading Section 9 on page 14, that the termination notice was not a negotiating position dressed up as a legal threat. It was a contractual right, triggered by documented material breach, executable with 30 days written notice. Raymond Osei did not need a court order to terminate the license. He did not need a judge's approval. He needed to send one letter. What termination meant for 340 households was not abstract. The board members all lived in those 340 households. They used the pool. They drove the roads. Their children had birthday parties in the community center meeting room. The gate was how they came and went from their own homes. A board member named Terrence Okafor, who had joined the board 6 months earlier and was attending his first crisis meeting, asked Herschel Dowd directly, if he terminates the license, can he actually close the roads? Herschel looked at the license agreement on page 12 of the notice. The roads are private roads, he said. They're titled to his trust. The license is what gives us, and our residents, the right to use them. If the license terminates, that right terminates with it. So we'd be residents of a development with private road access that was no longer licensed to them, Herschel said. Yes. Terrence was quiet for a moment. How do people get to their houses? That, Herschel said, is the question Mr. Osei would like us to resolve before day 30. Patrice came to my door on Saturday morning, day 4 of the notice period. I was having coffee at the kitchen table when the knock came. Archie lifted his head from the floor, decided it wasn't worth getting up for, and put his head back down. She was alone. No clipboard. She was wearing a jacket and had the specific expression of someone who had not slept well and had spent the night composing and discarding versions of what she was about to say. I opened the door. Mr. Osei. She stopped, started again. Raymond. I wanted to. The call I made to the non-emergency line. About the mailbox. I want you to know that I didn't. I let her finish the complete explanation. She had not known who he was. She had not understood the ownership structure. She had been acting on her understanding of her role and the community's rules. She was sorry that a police officer had come to his home. When she finished, I said, "You called the police because I told you my property wasn't subject to your HOA. You were right that it wasn't. You were wrong about why. I didn't know who you were. I know you didn't. That's the problem we're going to fix. Not just for me, but for every board member who has been making capital decisions on property they never verified they owned. And for every homeowner who has been paying assessments for improvements on land that belonged to someone else." I looked at her steadily. The fix isn't an apology for the phone call. The fix is the negotiation. Patrice, are you going to close the roads? I looked at her for a moment. At the street behind her, a resident from the far end of the court pulling out of their driveway, driving my road, heading wherever they were going on a Saturday morning. Go to your board meeting, I said. Have your attorney call Grace. I closed the door. I picked up my phone and called Grace before I sat back down. Patrice just left my porch, I said. I know. Their attorney called me an hour ago. Herschel Dowd. And apparently Craig Weston has his own counsel now. Craig's personal attorney was at the emergency session. That tells me Craig is separating his exposure from the board's, Grace said, which tells me he knows his legal is reviewing it. Response to your 2023 letter is the most defensible position on the board, and it's still not very defensible. What did Herschel say? He wants to schedule a principals meeting for early next week. He used the phrase, explore a path forward. He asked whether the termination notice was firm. What did you tell him? I told him the termination notice is what Section 9 says it is. I told him the path forward runs through a negotiation framework that my client will provide, and that the 30-day clock runs regardless of when we schedule the meeting. Good, I said. Raymond, they're going to come to the table ready to settle. The question is what you want the settlement to look like. I looked out the front window at the mailbox post. Charcoal gray, same as always. The color that had started the sequence. The violation notice, the police call, the officer at my kitchen table, the 14-page certified letter that had reorganized 7 board members' understanding of the community they were governing. All of it, in the end, because Patrice Lemon had stepped off her porch with a clipboard. I want the amended license agreement recorded before any money changes hands, I said. The financial resolution matters, but what I want to exist permanently is a recorded instrument that every future board member, every new resident, every lender and title company doing business in this development has to read before they proceed. A covenant that can't be forgotten the way the first one was. A document that does what Walt Grover should have done in 2021 when he packed his boxes, I said. One that makes the ownership structure impossible to inherit without understanding. I'll draft the negotiation framework this weekend, Grace said. We meet Monday. We meet Monday, I said. I finished my coffee. Archie was asleep on the kitchen floor, undisturbed by any of it. The principals' meeting on Monday lasted 4 hours. Grace and I sat across from Herschel Dowd, Craig Weston's personal attorney, a litigator named Frank Sutter, who specialized in professional liability defense, and whose presence confirmed that Craig had correctly identified his individual exposure as distinct from the HOA's, and 2 board members Herschel had brought as institutional representatives. Terrence Okafor, the newest member, and Lynette Farrow, whose July 2023 emails to Derek Anston had put her in the specific position of someone who had known there was a question and had accepted Craig's assurance as an answer. The meeting produced one thing, a shared understanding that the negotiation was going to be complicated by the gap between what the HOA's insurance might cover and what the documented damages actually were. Herschel wanted to know the filing timeline. Grace told him. He asked for 2 weeks to have his carrier assess the exposure. Grace said she would file in 10 days regardless. She filed in 9. The Superior Court filing covered 4 counts, structured in the sequence that built from the most straightforward to the most consequential. Count 1. Breach of the recorded license agreement. The instrument was a public record. Section 6's improvement consent requirement was unambiguous. The 4 capital projects, pool renovation, road resurfacing, community center expansion, entrance gate upgrade, had each been executed on trust-titled parcels without a signed improvement agreement. The breach was documented in the HOA's own records. The board minutes authorizing each project, the contractor invoices, the permit applications, and the absence of any improvement agreement in either the HOA's files or the county recorder's records. Count 2. Unjust enrichment. This was the count that connected the HOA's institutional failure to the 340 homeowners who had funded it. The pool renovation had been paid through a $1,000 per household special assessment, $340,000 collected from residents to improve a facility on a parcel the HOA didn't own. The road resurfacing and gate upgrade had come from operating reserves built from monthly dues. In each case, homeowner funds had been directed to capital improvements on Raymond's property, generating a material benefit, upgraded infrastructure, that attached to the trust's assets without compensation to the trust. The unjust enrichment doctrine requires that a party who receives a benefit at another's expense, without justification, must account for that benefit. Count 3. Trespass by permanent improvement. The legal concept was straightforward. Constructing a permanent structure on titled private property without the owner's authorization is a trespass, regardless of whether the trespasser believes they have authority. The community center addition was 1,400 square feet of permanent construction on Raymond's parcel. The entrance gate was embedded infrastructure on Raymond's entrance parcel. Both had been built without consent. Both remained on his property. The trespass was ongoing. Count 4. Declaratory relief. Grace had added this count specifically because the financial resolution, whatever it was, would not by itself prevent a future board from making the same assumptions. The declaratory count asked the court to issue a formal declaration of the trust's ownership rights in the Briarwood Commons common parcels, and a declaration of the HOA's obligations under the license agreement going forward. A judicial document that would exist in the case record and could be referenced by any future party who claimed ignorance of the ownership structure. The financial demand was built from 4 independently documented figures. Unauthorized improvement restitution, $771,000. The sum of the 4 projects' costs, calculated as the value of capital improvements made to trust-titled parcels without authorization. Grace's theory: the improvements had increased the assessed value of the trust's assets. The pool facility was more valuable after a $340,000 renovation than before it. But the trust had not authorized that investment and had not been compensated for the use of its property as the investment's platform. Restitution of the full project cost was the appropriate remedy. Retroactive license compensation, $890,000. The license agreement had set a nominal annual fee for the HOA's use of the trust-titled common areas and amenity facilities. That fee had been grandfathered from the Hargrove-era arrangement and was commercially below market for the scope of use. 340 households using a pool facility, a community center, and 3.8 miles of private roads. Grace's real property valuation expert had assessed the fair market license fee for the HOA's use of those facilities at $148,000 per year. Over 6 years, the difference between the nominal fee paid and the fair market rate represented $890,000 in undercompensated use. Trust asset diminishment, $340,000. The unauthorized modifications had altered Raymond's parcels in ways that affected their future use and market value. The community center addition had expanded the building's footprint on a parcel where Raymond had not authorized construction. The gate infrastructure had embedded automated systems in the entrance parcel. A licensed property appraiser had assessed the diminishment in the trust's flexibility to use or develop those parcels as the owner saw fit. The value of the owner's unrestricted discretion over their property, reduced by permanent improvements they had not consented to, at $340,000. Punitive damages, $1.4 million. This was the figure that Herschel Dowd had spent the most time on in the Monday meeting, and the figure that Grace had built the most carefully. The punitive predicate required willful or wanton conduct under North Carolina's standard. The pool renovation and road resurfacing, completed before Grace's 2023 letter, were institutional negligence, not willful conduct. Grace had not included them in the punitive analysis. The community center completion and the gate installation were different. Both had occurred after Grace's July 14, 2023 letter had placed the board on explicit written notice of the improvement consent requirement. The letter had named the community center expansion specifically as an ongoing violation and had requested an immediate construction halt. The construction had continued for 4 months and been completed. The gate project had been approved 3 months after the letter and installed 5 months after it. The board had been told. They had proceeded. That sequence, notice, acknowledgement, continued construction, new project approval, was the factual foundation for willful conduct. The punitive figure of $1.4 million represented approximately twice the value of the 2 post-notice projects combined, a multiplier consistent with North Carolina punitive damages case law in property rights matters. Total demand, $3.401 million plus attorney fees. The HOA's directors and officers' insurance carrier received Grace's filing on the same afternoon it was served on the board. The coverage reservation letter arrived 7 days later. 4 pages from the carrier's legal team, written in the specific, careful language of an insurance company that has read a claim and is working through whether it wants to be associated with the outcome. The carrier's analysis divided the 4 capital projects into 2 categories. The pre-notice projects, the pool renovation, and the road resurfacing, were potentially covered under the D&O policy's errors and omissions provision. Board members who had made capital decisions without knowing about the license agreement because the institutional knowledge of its existence had been lost after Walt Grover's departure, might be characterized as having made a good faith error in their governance function. The carrier was not conceding coverage on those projects, but it was not declining it on those grounds either. The post-notice projects were a different matter. The community center expansion had been completed after Grace's letter. The gate project had been approved after Grace's letter. The carrier's letter quoted Grace's July 14, 2023 correspondence, which had been included in Grace's filing as Exhibit H, and noted that the board's decision to proceed with both projects after receiving that letter raised the intentional act exclusion question directly. The intentional act exclusion in the HOA's D and O policy excluded coverage for claims arising from acts the insured knew or should have known were wrongful at the time they were taken. A board that had received a letter specifically identifying a license violation, specifically naming the community center project as an ongoing, unauthorized construction, and specifically requesting a halt, and had then completed that construction and approved a new project, was a board that had known or should have known its actions were unauthorized. The carrier's position: coverage reservation on all 4 counts, with the post-notice projects flagged for likely exclusion. They're going to decline the post-notice projects, Grace told me when the letter arrived. The pre-notice projects they might contribute to, but $251,000 of the $1.4 million punitive demand is the portion attributable to Craig's proceed as planned decision. That's the exposure the carrier is most skeptical of covering. And Craig's personal attorney. Frank Sutter has been in contact with Herschel twice this week, Grace said. Craig is negotiating his own resolution, separately from the HOA's. The secondary consumer protection filing went to the NC Attorney General's Consumer Protection Office on the same day Grace served the HOA. It was a referral, not a lawsuit. Grace's role was to present the factual basis for a potential AG enforcement action and let the office determine whether to proceed independently. The factual basis was this: 340 households had paid special assessments and monthly dues that funded capital improvements to property the HOA did not own, under the representation, implicit in every assessment notice and board communication about those projects, that the HOA was improving its own community infrastructure. The pool renovation assessment notice, sent to all 340 households in February 2021, had described the project as a capital improvement to Briarwood Commons. HOA common area facilities, funded through a one-time special assessment of $1,000 per household. The Briarwood Commons HOA did not own the pool facility. The pool facility parcel was titled to Raymond Osay's trust. The assessment had collected $340,000 from homeowners to improve someone else's property without disclosing that the property belonged to someone else. North Carolina General Statute 75-1.1 prohibited unfair and deceptive acts or practices in commerce. Collecting assessments for capital improvements to property the collecting entity did not own, without disclosing the true ownership structure to the homeowners funding those improvements, satisfied the elements of an unfair and deceptive practice, regardless of whether the deception was intentional. The AG's Consumer Protection Office opened a formal inquiry within 18 days of Grace's referral. An investigator contacted Herschel Dowd's office on a Thursday, requesting the HOA's complete assessment collection records for the pool renovation and all subsequent capital projects. Herschel called Grace that afternoon. "The AG's office contacted us," he said. "I know," Grace said. "I referred them." A pause. "Grace, how many fronts are you running this on?" "As many as the facts support," she said. "Your client spent $771,000 of homeowner money on my client's property. The homeowners are my client's neighbors. They deserve to know what their assessments were actually paying for." Another pause. "Frank Sutter wants to schedule a separate call," Herschel said. "Craig is prepared to provide a full account of the 2023 letter and the board's decision-making process in exchange for a consideration on the punitive exposure. Tell Frank to send the written account first," Grace said. "We'll discuss consideration after we've read it." She called me immediately after. "Craig is going to cooperate," she said. "He's going to provide a written account of everything. Who knew about the 2023 letter? What was discussed? Who said proceed as planned, and why? Does that help us or hurt us?" "It helps us on the punitive count," Grace said. If Craig's account confirms the board was explicitly told and explicitly decided to continue, the willfulness finding is no longer something we have to argue. It's something he's admitting in writing. I thought about that for a moment. What does he get in return? A reduction on his personal punitive exposure. He's trying to separate his liability from the HOAs. He approves the proceed as planned direction at the August 2023 meeting. The gate project gets approved 3 months later. His fingerprints are on both post-notice decisions. Let him write the account, I said. Whatever he puts in it, it becomes part of the record either way. Either way, Grace agreed. The negotiation ran 6 weeks from the Monday principals meeting to the settlement signing. Herschel Dowd managed the HOA's side of the table. Frank Sutter negotiated Craig Weston's personal resolution on a parallel track, which created the specific dynamic of 2 defense attorneys occasionally working against each other's interests, while Grace worked steadily toward a single, consolidated number that covered everything. Craig's cooperation, his written account of the 2023 letter, the August board meeting, and the proceed as planned decision, arrived in Grace's office on the Thursday of the first week. It was 11 pages, single-spaced, written with the careful self-preservation instinct of someone who had spent a week with a litigator before putting anything on paper. It confirmed everything the board minutes had suggested. Craig had read Grace's July 2023 letter on the day it arrived. He had forwarded it to Herschel with a note that said, "Can you review and tell me how serious this is?" Herschel had responded 4 days later with a 1-paragraph assessment characterizing the license agreement as a document whose application to the specific projects was subject to reasonable dispute, and recommending that they continue with planned work while the legal question was evaluated. Craig had taken subject to reasonable dispute as permission to proceed. At the August 2023 board meeting, when Lynette Farrow and Derek Anston had asked about the letter, he had relayed Herschel's framing. Legal is reviewing it, without mentioning that Herschel had already provided an assessment, or that the assessment had been optimistic in the specific way that assessments sometimes are when the client wants good news. The community center expansion had been completed in November 2023 without a follow-up legal review. The gate project had been brought to a vote in November 2023, the same month the community center was completed, without anyone asking Herschel whether the reasonable dispute characterization had been resolved. Craig's written account did not use the words, "I knew it was wrong." It used phrases like, "I relied on counsel's assessment," and "the board proceeded in good faith based on the information available." But the sequence it described, letter received, optimistic assessment obtained, board told nothing substantive, construction completed, new project approved, was the sequence Grace had already documented from the board's own records. Craig's account added the detail of Herschel's 1-paragraph assessment and the specific chain of reliance that had carried the board from July 2023 to January 2024, without a single substantive conversation about whether they were building on someone else's property. Grace read it and called me. "He's confirmed the chain," she said. His defense is reliance on counsel. Herschel's defense is going to be that his assessment was a preliminary opinion, not a green light. They're going to point at each other. They already are. Frank Sutter sent Herschel a letter yesterday, suggesting that Herschel's failure to advise a construction halt contributed to the board's continued exposure. Herschel has not responded warmly. What does that mean for our number? It means neither of them wants this to go to trial, Grace said. Because at trial, Craig testifies about what Herschel told him, and Herschel testifies about what Craig asked him, and the jury watches 2 professionals explain why the other one is responsible for $771,000 worth of unauthorized construction on a neighbor's property. The exchanges moved in the predictable rhythm of a negotiation, where both sides know the destination and are managing the distance between their starting positions and the floor. Herschel's first formal proposal had arrived in the second week, $1.2 million total, structured as restitution for the 4 projects only, with no retroactive license compensation and no punitive component. His framing: the HOA had made good faith governance decisions based on an inherited ownership assumption that no board member had reason to question. Grace's response: the good faith framing dissolved at July 14, 2023. Everything before that date was an inheritance problem. Everything after it was a decision problem. She held the retroactive license compensation figure, $720,000, reduced from the $890,000 in the original demand as a negotiating concession, and held the punitive component at $875,000, down from $1.4 million, attributable specifically to the two post-notice projects and Craig's role in directing continued construction. By the fourth week, the negotiation had converged on the restitution and retroactive license numbers. The remaining gap was the punitive component. Herschel at $600,000, Grace at $875,000. Both of them aware that the AG's consumer protection inquiry was running in parallel, and that a prolonged negotiation increased the probability of the AG's office opening a formal action that would add parties and complexity to the resolution. Frank Sutter called Grace directly on a Friday afternoon in the fifth week. Craig was prepared to contribute $275,000 personally toward the punitive component in exchange for a release of his individual liability. His D&O coverage was contributing the balance. Grace called me. $275 from Craig personally, she said. The HOA's carrier is covering $600,000 on the punitive count. They reversed the post-notice exclusion after Craig's written account framed his reliance on Herschel's assessment as the operative decision. The carrier decided it was defensible as an errors and omissions claim after all. So the carrier found a way to cover it. They found a way to cover $600,000 of it. Craig is absorbing the personal share. The final settlement was signed on a Tuesday morning, 6 weeks after the principals' meeting. Restitution for the 4 unauthorized capital projects, $771,000. Every dollar spent on Raymond's property without consent, returned. 6-year retroactive license compensation, $720,000. 6 years of 340 households using a pool, a community center, and 3.8 miles of private roads at below-market license rates, reconciled to fair market value. Trust asset modification damages, $340,000. The appraiser's assessment of the reduction in the trust's unrestricted discretion over its own parcels, caused by permanent improvements installed without consent. Punitive component, $875,000. $600,000 from the HOA's carrier, $275,000 from Craig Weston personally. Total settlement, $2.706 million. The amended license agreement was the document I had told Grace I wanted recorded before any money changed hands. It superseded the 2018 original in every respect, not replacing the 2018 instrument's recording, but layering on top of it, referencing it by instrument number, and expanding its terms with the specificity that 6 years of institutional amnesia had demonstrated was necessary. The new agreement was 22 pages. The use rights section was unchanged. The HOA retained full access to the common areas, amenity facilities, and road network for community purposes. That had never been the dispute. The HOA's right to use the infrastructure was legitimate. The dispute had always been about what the HOA could do to the infrastructure without asking. Section 6, the improvement consent requirement, had been expanded from the original 2 paragraphs to 8. The definition of capital improvement was explicit. Any expenditure over $5,000 directed at altering, enhancing, or expanding any trust-titled parcel, including landscaping modifications, structural work, mechanical systems, and surface infrastructure. The improvement agreement process was outlined in step-by-step sequence. Written proposal submitted to the trust, 30-day review period, written consent or written objection. No contractor engagement before consent is received. Section 7, new, required the HOA's board to conduct a mandatory annual review of the license agreement at the first board meeting of each calendar year, with the full agreement read aloud into the meeting minutes, and each board member signing an acknowledgement confirming they had reviewed its terms. Section 8, new, established the annual license fee at $85 per household, payable to the Raymond Osei Land Investment Trust in a single annual remittance each January. The fee would adjust annually with the Consumer Price Index. Section 12, new, required that every HOA board orientation package for incoming members include a copy of the license agreement, the amended instrument, and a 1-page summary of the trust's ownership interests in the development's common parcels. The summary had to be signed by each new board member within 30 days of joining. Grace had added Section 12 specifically because of Walt Grover. The problem had started when institutional knowledge walked out the door with a departing president. The solution was to make the knowledge structural rather than personal, embedded in the onboarding process rather than dependent on any individual's memory. The amended agreement was recorded with the county on a Wednesday. It attached to every trust-titled parcel in the development. Every future title search, every refinancing, every real estate transaction involving Briarwood Commons would surface it. The knowledge was now in the record. The membership called for Craig Weston's removal the week after the settlement was announced. The settlement terms had been shared with the full membership in a written notice from the incoming board leadership, a transparency measure that the new board's interim chair, Terrence Okafor, had insisted on. 340 households had learned, from a two-page summary, that their HOA had spent $771,000 of their assessment funds on property belonging to their neighbor, had been notified of the problem in July 2023, had completed 2 more unauthorized projects after that notification, and had settled the resulting legal action for $2.706 million. The membership vote on Craig's removal was called by petition and held at an emergency meeting 12 days after the settlement notice went out. 287-18. Craig sat in the back row of the community center meeting room. My community center. The building with the 1,400 square foot addition his board had built without my consent, and received the vote count without visible response. He had been on the Briarwood Commons board for 6 years. He had managed the pool renovation, the road resurfacing, the community center expansion, and the gate upgrade. He had steered the board through what he had characterized as a manageable legal question, and had delivered them a $2.706 million settlement and a county-recorded admission of 6 years of unauthorized construction on a neighbor's land. 287-18. He stood, gathered his materials, and left the meeting without addressing the floor. Patrice had resigned her board seat the week the settlement was signed. A letter to the board, 2 sentences, no elaboration. She had been the architectural review chair for 4 years. She had issued violation notices, managed the approved color palette, and maintained the specific authority of someone responsible for keeping Briarwood Commons looking like Briarwood Commons. She had called the police over a mailbox post and had ended up as the event that triggered a $2.706 million settlement and a 22-page recorded instrument that would outlast every current board member's tenure in the development. The incoming board's first formal resolution, passed unanimously at the organizational meeting following Craig's removal. Mandatory annual review of the license agreement. Full text read into the minutes. Every board member signing the acknowledgement form that Section 12 required. Their second formal act, a written apology to Raymond Osei, printed on HOA letterhead, signed by all 5 incoming board members, delivered by Terrence Okafor on foot to my front door on a Thursday afternoon. Terrence had knocked. I had opened the door. He had handed me the envelope and said, "From the board, and from me personally." I had thanked him and shaken his hand. He had looked at the mailbox post on his way back down the path, the charcoal gray that had started everything, and had kept walking without saying anything. It was a Saturday morning in early April when Carol came across the street. The Bradford pears had finished blooming and dropped their petals 2 weeks earlier. The spring had moved on to the next thing. Dogwoods along the back of the development, the common area plantings that the HOA's landscaping contractor maintained on a schedule that now required, per Section 6 of the amended license agreement, assigned improvement authorization for any planting work over $5,000. Archie was on the porch with me. He had found a patch of sunlight and occupied it with the focused dedication he brought to anything horizontal and warm. Carol Pemberton lived directly across Briarwood Court, a house she had owned for 9 years, one of the 340 households that had paid a $1,000 special assessment in 2021 for a pool renovation on someone else's land. She was a high school biology teacher, a reasonable person, and one of the neighbors I had spoken with most in my 11 years on the street without ever discussing what I owned. She crossed at the corner, my entrance parcel, the gate infrastructure visible at the end of the drive, and came up the front path. "Raymond," she stopped at the porch steps. "I've been meaning to come over since the notice went out. Is it true you've owned all of this since 2018? The land under the common areas, the amenity buildings, the roads, the entrance, since February 2018. She was quiet for a moment, processing the specific recalibration of understanding that everyone in the development had been doing since Terrence's notice arrived. And you never said anything. I looked down the street. The road curving into the development's interior, past the community center, past the pool facility entrance, toward the cul-de-sacs at the far end. My roads, my facilities, my neighbor walking her dog in the distance on my road, going wherever she went on Saturday mornings. The deed said it, I said. I didn't need to. Carol looked at the mailbox post. Is that why you kept it that color, the gray, even after she sent the violation notice? I looked at the post. Archie shifted in his sunlight patch, resettled, closed his eyes. No, I said. Carol waited. I just like it. She laughed. A genuine one, the kind that arrives when the tension of a long story finds its smallest possible resolution. She said goodbye, walked back across the street, used my road to get there. Archie did not open his eyes. The development was quiet in the April morning. The gate working, the roads maintained, the pool facility opening for the season next weekend, the community center available for the book club on Thursday. Everything functioning the way it had functioned for 6 years, with one difference. Everyone now knew whose land they were standing on.